Hi, my name is Randy Kim, and I'm a law student at the University of Pennsylvania. In this video, I want to provide some important background and context about the arguments in Katz v. United States. One way we can look at this case is through the lens of competing theories of judicial interpretation. One famous school of thought is textualism. Textualist judges believe that interpretation of a statute must be strictly limited to the ordinary meaning of the legal text of that statute. Closely related to textualism is originalism. Originalist judges believe that a statute should be interpreted according to what a reasonable person would have thought it to mean at the time it was adopted. On the other side, proponents of living constitution theory argue that the Constitution is dynamic and flexible. Living Constitution judges believe that pragmatic policy considerations demand evolving interpretation, or that the framers of the Constitution actually intended the text to be interpreted flexibly. These judges might argue that the plain text or original meaning of the Constitution could not have foreseen automatic rifles replacing single-shot muskets, or an evolving notion of human dignity that views women and minorities as having equal worth as white men. Thus, what matters to the living Constitution judge is the spirit of the law and not an outdated, narrow interpretation. Keeping these theories in mind, let's turn to the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Do you see where the different schools of judicial interpretation might disagree? Suppose you are a strict textualist. Does a public telephone booth qualify as a person, house, paper, or effect? What about a conversation? Can spoken words be searched or seized? What if you are a strict originalist? Is it likely that a person in 1789, when the Fourth Amendment was introduced, could have meant that telephone conversations were entitled to protection before the telephone was even invented? Now imagine you are a proponent of a flexible living constitution in 1967 when the court decides to hear the Katz case. What do you think would happen to our rights if technology allows more and more law enforcement encroachment on our private lives because the Fourth Amendment doesn't literally protect against warrantless wiretaps? 50 years later, does the strength of each side's arguments change? What if a government satellite photographs something in your walled backyard? How about if thermal imaging allows them to see whether you are growing marijuana in a bedroom closet? The Fourth Amendment protects letters, but what about emails? Do police need warrants for these kinds of intrusions? Nor does the argument between textualists and living constitution proponents end with police searches. The disagreement in Katz between opposing theories of judicial interpretation over what kind of rights exist that aren't specifically enumerated cuts to one of the biggest questions in constitutional law. Does the Constitution guarantee a general right to privacy? Some of the 20th century's most important and controversial decisions rest on the answer to this question. The right to contraceptives, a woman's right to bodily autonomy, the right to engage in consensual sexual relations with someone of the same sex. All of these rights have been protected by Supreme Court cases that rely, for better or worse, on the idea that privacy is a constitutionally protected fundamental right, even though it isn't explicitly enumerated in the document.